today. I love these town halls. I love the chance that we're able to share some of the good work that we're doing and the expertise that we have here at the Department of Labor and Industry. I'm Kathleen O'Leary. I'm the Deputy Commissioner here, and one of my favorite parts of my being able to share all of this good information. If you're new to our employer town halls, this is a forum that we've been using for a little over a year to reach out to employers across the state just on information that we are fielding a lot of calls on. And so we just kind of do a survey and find out what it is people are asking, and then we try to provide that information to all of you in a format that condenses all the information and you're able to access at any time going forward. So we do record these. We place these on our website. The link is in the chat there for all of you to see. So you're welcome to come back and listen to it again or forward that link on to any other interested parties who may want to hear the information as well. A couple other things, we do have a chat box here. I encourage all of you to jump on the chat box. We use it for basically 3 different reasons. If you have any questions about the topic that we're discussing, I welcome and encourage you to please put those in there for us. If we have time, we'll circle back around and try to answer them for you. If we're unable to answer them during this hour, we will go back and try to hook back up with you to get you that information, or we'll place it on our website as well. So please put any questions that you may have as we're going through this next hour in there for us. I also request if you have any suggestions for future town halls, things that you would like to hear more about, please place that in there. And also, if you want to be added to our email list that sends all the information about future town halls, please put your email address in there as well. Let's see, other housekeeping, just a general disclaimer. Some of the information we're providing is legal information. We cannot provide legal advice, but the information we're presenting today is general guidance for all of you. But we do suggest for your particular situations that you do reach out to your own legal experts to make sure that what you are applying and what you are hearing today matches your particular situation. So with that, I'm really excited about our topic today, human rights. Our Human Rights Bureau does really good work for us. Employers interact with them on a regular basis, and we have 2 really great experts sharing all of the information and knowledge they have with all of you here today. So I will hand it off to each one of them to introduce themselves and what makes them an expert, and also what it is that excites them about human rights and working where they do, and the topic of discrimination. So Marique, I'll start with you if you want to introduce yourself.
Well, thank you again, Kathleen, for this opportunity. I'm always glad to participate in these town halls. So this is great. Again, my name is Marique Beck. I'm the Bureau Chief over here at the Human Rights Bureau. I was actually counsel for the Human Rights Bureau. I've been with DLI for about 20 years, and I guess I'd say that's what probably makes me an expert in the field. I really do love this work. It's really interesting. I believe in what we do. If you know me, you know that I'm annoyingly enthusiastic about the laws that we enforce and the administrative process. Attorneys will tell you that all the time. And I think right now it's just a flat out really interesting time for civil rights. I think the Bureau's work is more relevant than it's been. So that's what I'd say.
Thanks. I love the fact that you're annoyingly enthusiastic, Marique. Andrea, what about you? You want to introduce yourself for the crowd out there today?
Yes, thank you. Hello, everyone. My name is Andrea Harden, and I'm the Targeted Equitable Relief and Training Coordinator for the Bureau. And in this position, one of the things I do is create and provide video and live training on state and federal discrimination law. So doing that, I have and continue to garner a broad understanding of those laws so that I can teach others. And it's a fairly new position for the Bureau. It was just created last year. So prior to, I investigated cases for the Bureau for a couple years as well. And I came to the Bureau after practicing law with Georgia Legal Services, mainly in the area of family law, which was rewarding and had its own type of drama and excitement. But what really excites me about what I do and the topic today is how getting this type of information out really impacts our communities on a wide scale, because it's information that affects how we treat one another on a daily basis and hopefully seeks to foster respectful interactions, which of course benefits everyone.
Perfect. Thanks so much, Andrea. I know the title of your position is a mouthful, but I'm looking forward to you sharing all of the good work that you have been doing in training and some of the videos that you've put together. They're just really good stuff. So we will be hearing more about that as we move along. Marique, let's start with you, and let's just start with the basics. What can you tell us about the Human Rights Bureau and what does it do?
Well, I always like to begin with telling folks that Montana, as I may have mentioned, has some great laws that protect every single one of us from discrimination. It all starts with our Constitution, Article 2, Section 4, and right down to some amazing state statutes, which are the Montana Human Rights Act and the Governmental Code of Fair Practices. Those are found at Title 49, Chapters 2 and 3. So at its most basic level, what the Bureau does is we enforce these anti-discrimination laws. And what this means is that if someone feels that he or she has been discriminated against and they want to recover under those state laws, they have to come here and file a complaint. So they're not walking into a district court and filing a complaint. You have to start with this administrative process housed inside the Department of Labor and Industry, or what is known as an exclusive remedy. And so once a complaint gets filed here, the Human Rights Bureau, we assign an investigator, and that investigator will conduct an informal investigation. Now, the purpose of the informal investigation is to determine, and the standard that we use is a preponderance of the evidence, whether there's a preponderance of the evidence supporting those allegations. But all that said, the Bureau is just the first stop on a much broader administrative process that I'm so enthusiastic about, and we'll be talking about more. Bottom line, we function sort of as a gatekeeper. We're determining whether a complaint stays inside of this administrative process or whether that person has to take their concerns elsewhere. But of course, as you can see from the slide that's up there, we do more than just investigations. We also do intake, which we'll be talking about a bit more. We have an extremely robust voluntary resolution program. And then finally, as Andrea mentioned, we do a lot of education and outreach. And as she said, it was just this past year that we were finally able to pick up our own trainer. And it has just been amazing. She's doing an amazing job. We've always been able to do training, but it was sort of hit and miss. And with her in place, we're really able to take it to another level.
I would completely agree. I love the good work that she is doing. Thanks, Marique. Andrea, I'm going to go to you and make sure that we're all on the same page here. Can you just give us just a general description on when we're talking about discrimination, what is it that we're talking about? And then maybe talk about some of the protected classes here in Montana.
Okay, so in its most basic terms, discrimination is when an adverse act is taken against someone because of their membership in a protected class in a protected area. And so breaking down some of those terms, a protected class that includes age, race, color, national origin, physical or mental disability, sex, which also includes the subcategories of pregnancy, sexual orientation, and gender identity. And then you also have creed, religion, and marital status. And as you can see on this slide here, Montana also recognizes the protected class of political belief when you're in the area of governmental services or government employment, and also the protected class of familial status in housing cases. Governmental services and housing are protected areas of anti-discrimination laws, and the laws enforced at the Bureau state that for an adverse act to be considered discriminatory, not only must the act be taken based on one of these protected classes, but it also must be taken in a protected area. And so aside from the governmental services and housing protected areas I just mentioned, the other protected areas are seen here on this slide, and they include employment, public accommodation, education, and for the protected classes of sex and marital status, you also have the protected area of credit, finance, and insurance.
Thank you for that background. I know that is a brief summary and there's a lot in all of those words, and we can dive into more of that as we go on. But Andrea, how does this work? How does a discrimination complaint end up in front of the Bureau?
Well, the Bureau gets complaints in a couple different ways. We have attorneys that draft and file complaints at the Bureau. We also have people that do their own write-in complaints. And then the Bureau also does intake. And intake is an hour-long appointment with an investigator to run through what the caller's situation is to see if what they describe falls under the laws that the Bureau enforces. And if it does, the Bureau will then draft a complaint for the caller, who we call the charging party. And once we draft that complaint, we send it to the charging party, and then it's on them. It's up to them on whether or not they actually return it to us for filing or not.
So Marique, I'm going to pivot back to you for a second to provide a little bit more information there. I have employers asking me on occasion about us drafting these intakes or doing the intake. So can you tell us, are we advocating for the charging party when we are drafting the complaint?
The simple answer is no. I mean, it is a really good question, and it does require just a bit of context. The Bureau is fielding about 5,000 calls in any given year. And on top of that, we're getting hundreds of letters. The very name of our Bureau, the Human Rights Bureau, it attracts a lot of attention, concerns that just simply don't fall within the Bureau's wheelhouse. So yes, Montana's laws are magnificent and contain a lot of protections, but we're not here doing, we don't enforce the Webster's Dictionary definition of discrimination. We only have the authority, as Andrea just set out, to enforce as it pertains to those protected classes inside of those protected areas. And so for this reason, there's just a lot of screening happening. Only 1 in 5 callers actually ends up with an intake. And then when we're doing this intake function, as Andrea mentioned, we're talking to that caller, we're walking through what happened, we're trying to figure out whether or not they're putting forth a viable complaint. One of the things we're also checking is whether or not it's timely. Under the laws that we enforce, you have to get a complaint in within 180 days of the adverse act or its discovery, with only very limited exceptions. So it's a pretty short time frame. So a lot of folks that we're talking to, they've already blown their SOL, statute of limitations. So for this reason, when the dust is settled, we end up only drafting complaints about half the time after an intake. Of course, a person is still free to draft and file on their own. Andrea mentioned that we do receive write-ins, but again, we've done our part in terms of educating that caller about what it is that we do, what our process looks like, what they have to look forward. When we're talking to callers, I want to make sure that you understand that we're emphasizing that just because we've drafted a complaint, it doesn't mean that we're taking a position on the actual allegations. So to answer the question, we offer intake because it's a way to make sure that we're actually getting viable complaints of discrimination. And I can say with some certainty that when you get a Bureau drafted complaint, that's going to be a lot easier to work through than say 35 pages of handwritten single-spaced letter that a charging party has put together. Our process ends up screening out a lot of invalid allegations and perhaps even entire complaints. And then when we're done and we do the draft, then everybody has a very clear roadmap for the investigation.
So in the end, instead of it being where you're advocating for the charging party, it really does help the employer as well as the charging party to navigate the process if you are the one that are drafting this.
Yes, in the end, we'd end up having to do something similar anyway. We'd have to sit down. Let's go back to that example of the 35-page handwritten letter. We'd have to walk through with that charging party for an hour or more and just try and figure out what's inside of our wheelhouse, figure out what allegations that we can take a look at and condense that to something that we could then give the respondent so it would have an opportunity to respond in a meaningful way.
Thanks for clarifying that. Andrea, I'm going to go to you as a former investigator. Can you tell us a little bit about what the investigation process looks like after somebody files a complaint with the Bureau?
Sure. So after a complaint is filed, we send it out to the respondent, which is the entity against whom a complaint has been filed, and we ask for it to file a response with us, letting us know what their position is on the allegations. And after that, the case is assigned to one of our Bureau's investigators. And not surprisingly, investigators spend most of their time asking questions to better understand each party's position. So for example, if we get a complaint from someone asserting that she thinks she was fired because of her age, will interview charging party and try to get an understanding on why she thinks her protected class motivated the termination. And of course, we're also talking to the respondent and getting their side of the story and interviewing witnesses that are identified during the investigation as well. And aside from interviewing the parties and the witnesses, an investigator will typically request documents like policies or personnel files, maybe some letters or correspondence, text messages, things that will help the investigator understand what happened and what motivated what happened. And the investigator will also want to know how the respondent treats others in similar situations. This is what we call comparators. So for example, if it's a disability complaint, does the employer have a pattern of refusing accommodations or granting them? And prior to COVID-19 and the shutdowns, when we were all still able to get together and mingle, an investigator would occasionally do an on-site inspection or on-site witness interviews to get a better understanding of maybe the circumstances of the complaint as well, if it would benefit the case. And then from there, once an investigator concludes the informal investigation, he or she will ultimately determine if the information gathered supports the allegations brought by the charging party. And we refer to this as a cause or no cause finding. And the standard that's used is a preponderance of the evidence, which just means that evidence suggests that something more likely than not happened. And this is a much lower standard than others, like clear and convincing or beyond a reasonable doubt that you hear used in criminal cases. But the standard that we use is the same as a district court hearing the case would use as well. And as you can imagine, it can take some time for the parties to gather all the documents needed and to schedule and get interviews completed. Then for the investigator to review and weigh everything, especially when you consider that each investigator is handling multiple investigations at the same time. But by statute, the investigation must be finished no later than 180 days after it was filed, and actually even less time, 120 days if it's a housing case. And so then once the investigation is complete, the investigator drafts a final investigative report and outlining the investigation and the finding, and that report is then issued to the parties.
Thank you. And that's a whole lot of steps in there. So thank you for that. The very succinct summary of that. Can you tell us a little bit about the final investigative report, Andrea? Who does that go to? What is the purpose of it? Just next steps. Tell us a little bit more about that.
Sure. So the closure of the case will then prompt the issuance of the final investigative report to just the parties. So the charging party and the respondent will get a copy and be able to see that. And the report will explain in detail to the parties what the Bureau considered when making its decision. It'll lay out the information and the analysis that was used in coming to that decision. And like mentioned before, the investigator will either recommend a finding of reasonable cause, meaning there is reason to believe that illegal discrimination occurred, or no reasonable cause, meaning that the evidence does not support a finding that illegal discrimination occurred. And if there is no cause finding, then the charging party has the option of appealing the Bureau's decision to the Human Rights Commission. And if that happens, then the report becomes part of the record that is reviewed by the Human Rights Commission. So that's kind of the life of the report that it goes through. And as Marique mentioned before, you should think of the Bureau's process as a type of gatekeeper. And since we are the first step of the administrative process, a discrimination complaint goes through rather than the ultimate decision maker, really. So the finding reached by the Bureau after an investigation simply determines whether that complaint stays inside the administrative process or whether that person can then file their complaint in district court.
I think that's a really great distinction, just identifying what your role is at that point, because I do think there's some confusion about that. So thank you, Andrea. Marika, along that line, and Andrea mentioned some of the steps, but we're just the first step in the administrative process. So can you provide a little bit more detail as to the big picture and maybe talk us through that process?
Certainly, sometimes I, given my age, refer to it as the Rube Goldberg flow chart. We only have a chunk of it up here, but I will recommend that folks do hop on our website. We have a full flow chart that sets it all out step by step and with descriptions. What I have up now is sort of an abbreviated version of what happens after the Bureau does its job. From the 500-foot level, what I'll say is that we have 3 tiers to the Bureau's administrative process. The system is designed in a way to have checks and balances. So the 3 steps, again, the Human Rights Bureau. After that, we have the Office of Administrative Hearings, and then the Human Rights Commission. So again, we've been talking up until this point about what HRB's role is. We are the ones that are performing that informal investigation. And then, as we've mentioned, if we find cause, then that complaint travels forward to the Office of Administrative Hearings. Now, this is after we've made attempts to conciliate. The final step of the administrative process that the department rolls out is that Human Rights Commission. You've probably heard of that. The commission is a 5-member citizen panel. The citizens are appointed by the governor, and they're in place to review the work of the agency, basically. So they're looking at both no causes that we send out, as well as decisions that are issued by the Office of Administrative Hearings. I'm going to mention that they meet every other month. And if you do have a chance, these hearings are open to the public and you can sit in and learn more. HRC meets next month in what is a very rare 2-day hearing. It's going to be happening on May 20th as well as May 21st. And as I said, it's a good opportunity to get more exposure to what it is that we do and what the arguments look like.
Great, that's a great suggestion. I didn't know about those dates, so thanks for that, Marique. I do want to back up a little bit. You referred to the Office of Administrative Hearings. So can you talk a little bit about that and what that looks like, what their role is?
Sure. So again, in those cases, and we'll talk about our stats about how often that happens, when the Bureau does find cause, where the preponderance of the evidence is supporting the charging party's allegations, the complaint will be transmitted over to the Office of Administrative Hearings. And these hearings are just like a contested case. They're held de novo. That means anew, without any consideration of the information that we gathered during our investigation. This is where the rules of evidence kick in, the rules of civil procedure kick in. Companies have to be represented in this forum. And here is where the charging party is going to bear the burden of proving that discrimination to that fact finder. One thing I do want to point out is that our report, under a couple of different Supreme Court decisions, Felco being the big one, our report doesn't usually go anywhere. It can't be admitted in one of these contested case proceedings because it is considered hearsay.
Yeah, thanks for that, Marique. And just can you provide a little clarification? That is a completely separate office from the HRB, correct?
Yes, so physically and in our flowchart, it is separate as well. We're all housed in different places. And as I mentioned before, the only document that travels from this shop over to OAH is just the complaint.
Right, thank you. Andrea, to pivot a little bit, if I'm an employer and a complaint is filed against me, what are my options in this whole process?
Sure. If you don't want to work through an outcome in the administrative process or the district court, you can mediate. The Bureau has a voluntary resolution program that's available to parties involved in a case filed with the Bureau, as Marie mentioned earlier. Most of our investigators have been trained in mediation as well, and we also have a dedicated mediator with decades of experience practicing employment and labor law. And I would point out that the cases that end up over in our mediation program, we are able to settle those complaints about 75 to 80% of the time. And this program is completely voluntary, meaning that both parties have to consent to participating, and it is free. The only downside, if you can even really call it a downside, is that the administrative process deadlines get extended just a bit, and that's mainly to provide a little bit more time, especially if the mediation is unsuccessful, because at that point, the case goes back to the assigned investigator to complete the investigation. So for example, one of those deadlines that get extended is that the investigator gets an additional 45 days that's tacked onto the 180 deadline in order to complete the investigation. And so there are many different reasons to participate in voluntary resolution negotiations. Voluntary resolutions can, of course, save the parties time and money. The negotiations are confidential, and a majority of the parties who choose to participate have their cases successfully resolved. And a resolution doesn't just mean money damages. I've been really surprised at my time here at the Bureau how often a charging party may just want some type of remedial measure like training or a policy review to prevent future discrimination. And I've even had a case settle on an apology.
Mhm. Yeah, right. All of us have different motivating factors, right? Are employers nervous about the resolution process? Can you talk a little bit about why it's, I guess, what their response has been to us offering these services?
I'll
Go ahead, Marie.
well, I'll hop in here and just again sing the praises of Stacy Welderly Wade. For those of you who practice out there, you know that she's been practicing on both sides of the fence for about 35 years plus. And if you go out into private and look at the costs associated with a legal mediation, those are normally clocking at about $2,500 or more. Stacy has a really good way of making the parties very comfortable and certainly does a great job listening. It's not so much a facilitative form of mediation, it's rather an evaluative, meaning that she's looking at what you're providing and telling you what she sees. And so again, that's all completely firewalled from what the Bureau will eventually do. But one way to think about it is that you don't really have anything to lose. As Andrea mentioned, all it does is extend the time frame for the investigation that we would be performing anyway.
Perfect. Thanks so much for that. Andrea, can you talk to us a little bit about the training that the Bureau does and some of the really great work that you've been working on?
Sure, thank you. I'm currently in the process of creating a comprehensive library of training videos related to every topic covered by the Bureau. And as these videos are completed, I'm posting them onto our YouTube channel, and they're available to everyone to watch. And you can find the videos by going to YouTube and searching Montana Human Rights Bureau. And we also have links to some of these videos on our website at www.montanadiscrimination.com. And aside from the links to video training on our website, you can also find posters and some brochures and other informational guides to learn more about the Bureau and discrimination. The Bureau has been invited to give presentations multiple times at different job service locations around the state, mainly through their Blueprint for Business Success program. And also we participate in the Department of Labor and Industry Safety Fest, which is a week-long training series on a number of topics of interest to employers. And Safety Fest is free and it's offered each quarter, by my understanding, in a different Montana city. Of course, this past year, it's been a virtual gathering. In addition to what I've mentioned already, the Bureau is always open to considering other training opportunities to give Montana's employers and employees and any interested citizens the information that they need to understand their rights and responsibilities under the Montana Human Rights Act.
Yeah, thanks. I would add, if you get a chance to go in and take a look at the videos that Andrea has put together, they're super informative. I listened to a couple of them this week and learned some things that I probably should have known ahead of time. So Andrea, thank you for your work on that. They're a great resource for employers out there. I would also add that Marique and Andrea and the Human Rights Bureau are a resource to all of the employers just for basic questions. So even besides training, feel free to reach out to the Bureau with any questions you have related to this topic. If they don't know the answer, they can certainly guide you to who can. And also a plug for Safety Fest as well. It really is a great training opportunity. I encourage you to take a look. I think we can put some information in the chat box with some links to that. Our next Safety Fest will be June, 14th through the 18th. It's going to be hosted by Haver. Again, it will be virtual. We've had really great response to our Safety Fest, even during the pandemic, with over 700 participants climbing onto those. So highly encourage you to take a look at those so you can listen to information about what the Human Rights Bureau does, but also other areas of DLI as well. Andrea, I'm going to go back to you. So how often is the Bureau reaching a cause finding in the cases that it investigates? And what seems to be the types of cases that are filed most often? Can you give us some stats on that?
Sure. The Bureau keeps a lot of data on the complaints that get filed. And if you go to our webpage, there's an entire section dedicated to what our complaints look like annually and a lot of other information. And here on this slide, you see there's two different graphs. The pie chart tells you by percentage the status of our closed cases, and the bar graph shows you the number of cases filed categorized by protected class, and this is for fiscal year 2020. So as you can see, 59% of our cases close with a no cause finding and 10% are cause. Also, we have a 15% rate of resolved through voluntary resolution, and that means that the case is settled and closed. The number of cases that are voluntarily resolved at the Bureau level jumps up to around 23% when you add in the number of conciliations that we do as well. And conciliations are voluntary resolutions after a cause finding. As far as the types of cases we see most often, disability and retaliation have been the Bureau's highest filings for years. I don't think the majority of these cases happen because of any bad intent. It's more just that people probably don't understand the laws. And in terms of retaliation, people may not see that an action that they take can be seen as something that would dissuade someone from objecting to discrimination. And disability laws are really complex. So I think there's a lot of confusion out there about what a disability is and the rights and obligations that come with that protected class.
Yeah, I appreciate you bringing that up. And again, if you take a look at some of the YouTube videos that Andrea has placed out there on the website for all of you, there's some really great 101 information on disabilities and retaliation that just kind of breaks it down into a format I think for employers is really easy to grasp onto. So I encourage all of you to take a look at those as well. Marique, I know that Andrea talked about the possibility of mediation after a complaint gets filed, but if that isn't an option, if I'm an employer, what should I do if a complaint is filed against me? Walk me through that process.
Well, first and foremost, I would caution against panic. Know that great employers have complaints filed against them, and it doesn't necessarily reflect on you as an employer. If you're not familiar with the Bureau and our work, take a moment to learn more. The Bureau does have a well-trained and professional staff. You can hop on our website, which I believe has been put in the chat a couple of times. And then we have other great resources out there, and we'll be putting up a resource slide here in a moment. After you get the complaint, definitely read through it, work to understand the nature of the allegations. You're going to want to prepare a response. I will point out that at this level, at the Bureau's level, you're not required to be represented. We're set up in a way that neither a charging party nor a respondent need counsel, but you're always welcome to use one. As the investigation unrolls, remember that it's important to be responsive. We definitely want to know your side of the story. So tell us who the best witnesses are. Give us the right documents. We want to understand the facts that are in contention. The bottom line is really good communication with your investigator. If you have concerns about what we're requesting, tell us. If you need an extension, give us a call. Really just work through your investigator to get to a point where you understand what we're investigating and where we're going. And I really can't say this loudly enough, and as long as I have the opportunity, I will. It's imperative that you not retaliate once a complaint gets filed. As Andrea mentioned, it's her second highest filing. It's completely understandable to react emotionally to the fact that you got hit with a discrimination complaint, but do not retaliate. We do have information on our website, including a PowerPoint on retaliation specifically. Towards the end of that PowerPoint, there are several best practices for an employer that's existing in a world with a discrimination complaint, and I'd suggest checking that out. So just to sum it up, when you get a complaint, don't panic. I've said it before, remember that great employers have complaints filed against them, and it doesn't necessarily reflect on you. We're going to work through it. And as Kathleen just mentioned, we are here as a resource. Just about every day I'm talking to an employer on the phone. Obviously, I can't provide you with legal advice, but I'm going to try and get good information in front of you. And I will also point out that we're not just here for private businesses. As we talked about in the very beginning, the Bureau also enforces the Governmental Code of Fair Practices. And of course, that's what is layered on top of all public entities. And I would shamelessly promote a town hall in the future on the Governmental Code of Fair Practices. So if you're out there and you work for a governmental entity, such as a school district, or you're working for county government, feel free to reach out to us as well.
Yeah, I think that's a really great reminder that they're certainly here for both public and private entities. So a couple things I heard you say there, Marique, I'm just going to go back for all the employers listing out there that we don't want to panic if a complaint is filed, that we're here to walk them through that process. If they have any questions at all or concerns or need some clarification, not only do we encourage them, we really want them to reach out and ask us those. So the process can be as seamless as possible and provide really good information to our investigators, and to really just use us as a resource. Did I miss anything there?
Nope, that's definitely it. We want the good information, and we're going to be as transparent with you as possible. What I always end up, and how I train my investigators, is we're not the gotcha people. So we're just really about being as transparent and getting the good information and figuring out what happened.
Can you also touch on a little bit, Marique, on and you briefly stated this, but an attorney isn't required for the investigative portion. Do you want to just provide a little bit more context around that?
Certainly, as I said, it is sort of an interesting thing here in Montana that you have to bring your complaint through an administrative process. And so unlike other states where if you have a complaint, you can just walk into the district court setting where everybody typically has to have a lawyer. But here in this administrative process, the very first part with the informal investigation, as a corporation, you're not required to be represented. Of course, that changes if you move into a contested case setting. But again, here at the Bureau, you're not required to be represented. That doesn't mean that you can't use an attorney, and certainly some folks choose to do that, but it's not a requirement in any way, shape, or form.
Right. I think that's a good thing for some of our business owners out there to hear, especially if they're smaller employers, that they don't need to bring that resource in, that we will help them through this process. So glad to hear you mentioning that. So we've kind of gone through some of the basic information. So I'm just going to throw out a couple of random questions, Marique and Andrea, that we hear a lot from employers. And right now, a hot one, Marique, I think I'll throw it your way. Andrea, feel free to jump in here, of course, is a lot of questions about how to handle vaccinations in the workplace. Do you have suggestions on where to get that information?
I do, and I'll just start with an explanation that here at the Bureau, we follow federal guidance to the extent that it's not conflicting with any state law. So our federal law in employment that we're looking at is often coming through the EEOC, the Equal Employment Opportunity Commission. And what they've done is put together just a really great FAQ, frequently asked questions for everybody on COVID-19. And there are questions and answers regarding vaccinations. If you take a look at that guidance, what you'll find is that if an employer does have a policy that requires vaccination, they must also offer certain accommodations, both for religious reasons and for medical reasons. That said, the one thing I want to make sure everybody on the call is aware of is that Montana's legislature is currently in session, and there are several bills that address the issue of vaccination and vaccination status. And they're in motion right now, so I can't speak with any certainty about what's going to happen there. And your best bet is simply hopping on the state of Montana's webpage. I think it's actually, I'm not going to go there. If you go to mt.gov, you can get to the legislature's webpage and seek out vaccination bills. But one thing that's happening, at least for me right now, and certainly it's also probably happening for some of you in your professions, there are various resources that are popping up. I just got sent, I think Eric sent it to me actually. I think the ABA is putting together a presentation on vaccinations in the workplace. And I know that right around the beginning of May, I want to say it's May 5th, the EEOC is pairing up with OSHA to do a presentation. And so if you're interested in learning more about this topic, you can certainly reach out and I can give you the information that I have. And I may also be able to suggest some conferences or presentations that I've come across.
I appreciate that. Thank you. Maybe we can put that on our website for people that are jumping on and just looking for information there. So people can, instead of calling, use that as a resource. I see Rebecca has put in the website link for the legislature. So people can go on there and track the various bills that are related to vaccinations that are in various steps along that whole process. So skipping to just another thing that we touched on, I think both of you mentioned that the majority of the complaints that you were feeling or inquiries that come in are related to, well, different kinds of discrimination obviously happening in the workplace. If somebody, an employer wants to lessen their likelihood of a complaint being filed, what are some things that you would suggest? Marique, I'll go to you for that.
Well, as we mentioned, disability is flat out our highest filing. And so if you were going to play the odds, I'd definitely take a look at learning more about disability discrimination. As Andrea mentioned, there's a lot of confusion about disability discrimination. It's pretty regulation rich. The good news is there is a ton of free good resources out there. And so on our resource page, in addition to the EEOC, you'll see two that fall below it, the Job Accommodation Network, as well as the ADA National Network. And they have webinars, they have Q&As, they have it all, as well as just being able to call up and ask questions. So again, if I was going to do one thing, I'd definitely educate myself on disability discrimination. If I could slide another one in there, I would also suggest having really solid discrimination policies in place. I am a firm believer that when employers and employees have good information, they can make good choices. It doesn't bulletproof you from having a complaint filed against you, but I think it puts you in a much better position to defend if there is a complaint. So we actually on our website also have sample policies. I'm not going to suggest adopting those wholesale. Rather, I would suggest looking through, figuring out what works for you and for your organization. But if you want more information on policies, definitely reach out.
Perfect. Thank you. Something else we hear a lot about is age. So what advice would you offer to an employer if they want to hire an employee around a specific age? Do you have any thoughts on that, Marique?
I have thoughts. First, understand that anyone who hires one or more people here in Montana, you're going to be subject to the Montana Human Rights Act. And here in Montana, our state laws protect no matter what your age is. So you're probably familiar with the Age Discrimination and Employment Act and the fact that that protects persons 40 up. But again, here in Montana, we protect persons regardless of their age. In our statutes, it says that you cannot advertise, you cannot restrict your applicants unless you have what is known as a bona fide occupational qualification. We refer to it as a BFOQ. And that's just another way of saying you have to have a really good reason for the age restriction. So going back to the example of the age restriction. And when I say really good reason, what I mean is a legally justified reason, not something based on stereotypes. One example would be, let's say you serve alcohol or something like that. And of course, there's laws that prohibit persons of a certain age from serving alcohol. The best advice is if you're putting together an advert or an application, really stick to merit and qualification. What's your skill set? What are your experience? Tell me about your education. Avoid protected classes. And if you are going to put a protected class, especially age, make sure that you've perhaps run that by an attorney and that it's solid.
So it's not just based on, say I have an unfortunate relationship with an employee who might be of a younger age. And so I decide as an employer that I'm only going to hire people over an age so I don't have to go through that again. Would that create issues for me as an employer?
Right, exactly. So that's something that was a personal experience, and it's probably singular, or maybe not singular, but what we're looking for is, as I said before, something that is legally justifiable. And so you're really, in many ways, looking to the outside world, including laws in the outside world, such as the Fair Labor Standards Act. There are age restrictions that exist inside of that, or state law dealing with weapons or alcohol.
So it can't just be your intuition or your gut. It has to be based on some other resource, correct?
That's definitely what the law is going to look for.
Okay, perfect. Thank you. So you've talked about this a little bit, Marique. How does all of this tie into the EEOC, and what does this federal agency have to do with the Bureau?
Well, the EEOC is our federal partner. So I think just understanding that there are state laws, the Montana Human Rights Act and the Governmental Code of Fair Practices, there are also federal laws that impact you as an employer. So for employers that have a sufficient number of employees, it's called the numerosity requirement, typically over 15, over 20 for the Age Discrimination in Employment Act. When a complaint gets filed, it's duly filed underneath both laws. And the good news is that just one of us will be doing an investigation. So again, when a complaint gets filed and it meets the requirements of both state and federal law, it will be considered duly filed, but you'll only be subject to one investigation. And the reason why we do the investigation on behalf of the feds is because our laws are basically substantially similar.
So it really saves time for everyone, making sure that there isn't two things happening that they're responding to, correct?
Exactly, exactly.
Great. So a couple other just varied questions for both of you. Can we talk about the probationary period for an employee? Marique, I would like to know your thoughts around probationary periods.
Right. So there's definitely some confusion when it comes for employers on what a probationary period allows you. So for folks who haven't heard, we're maybe the only not at will state in the nation. And what we have is something known as the Wrongful Discharge from Employment Act. And under this particular piece of legislation, which is wholly separate from the laws enforced by the Bureau, employers are afforded, or they are not subject to a wrongful discharge from Employment Act if they terminate somebody inside of a probationary period. And this has created a little bit of confusion because they feel that they're also not subject to the laws that are enforced by the Bureau. So I want to be sure that we're clear about that. Whereas you might not be subject to a complaint under the Wrongful Discharge from Employment Act if you terminate a probationary employee, you are still subject to the laws that are enforced by the Bureau.
And again, you and your staff are available for questions for anyone that might have little inquiries or concerns about that topic. Andrea, I'm going to pivot back to you for a second. What can we tell employers about how they can change or improve their hiring practices as it relates to the Bureau?
Well, I think the first thing they can do is look at how they're advertising their vacancies. You should really consider putting in some language that does its best to sincerely express a desire for diversity in the workplace. And of course, I don't think that that includes we're an EEO employer, because I don't think most people really know what that means. And there was a posting that went around the other day that said something to the effect of, our employers are like our toppings. They're all different, but come together to make the ultimate pizza. And so that's a good example. It could be worded even stronger, but it puts the idea of diversity out there. And so the next thing, when you put together an advertisement, the next thing you should do is don't assume that the language that you're using will be understood by everyone. I think it would be a good practice to have someone objectively review your posting to make sure it's both accessible and interesting.
Yeah, I would agree with all of those things. I know, Marique, I think it was about a year ago, we did a employer town hall on diversity. Did you want to add anything else for employers around that topic? I know that it's something that you are passionate about as well.
Well, definitely. As Andrea mentioned, definitely starting with how you're bringing people into your shop, making sure that you're working with a diverse workforce is how you're going to be, or build a better widget, as I always end up saying. But then once you have, it's also important to retain folks. And so, as we talked about before, this is where you have those great discrimination policies, and you're making sure that diversity is something that is messaged and honored in a way that is sincere throughout everything that you're doing. It's in your staff meetings, it's in the emails that you send out. And again, it's in the policies that everybody's getting. And certainly it's not something that, I was just talking to somebody who worked someplace the other day, and they said that the employer handed the policies to them and asked them to sign it, and then took the policies back, so that they actually didn't even have a copy of the policy. So you want to make sure that your employees know the policies and understand what their rights and responsibilities are. So that would be my suggestion.
Yeah, I completely agree with that. And I know this isn't on the list of questions we talked about, but would you touch a little bit on accommodations? I know that that's a topic that comes up and employers get concerned a little bit about accommodations. Just in general, what are some words of wisdom or some guidance you would give employers?
The number one thing, at least anecdotally, I can say, is make sure that you're well equipped to recognize a reasonable accommodation request. And so what am I saying? Basically, if you have an employee and he or she expresses that they have a medical condition and that it's somehow impacting their ability to do their job, you want to sit down with that person and engage in what is known as an interactive process. You want to know more. They want to know more. You want to figure out if you can put a reasonable accommodation in place so that they can continue to perform the essential functions of the job. That interactive process, the whole concept of reasonable accommodations, I'm glad we still have the resource slide up, because if you hop on either the Job Accommodation Network, you can get a ton of great information, as well as that ADA National Network. And then, of course, Andrea has done some absolutely amazing videos on that you can find on our website.
Yeah, Andrea, do you want to touch on some of those videos? There's good stuff in those.
Oh, goodness. Yeah. So I have been able to get the disability topic up there pretty well covered for right now. I'm just going to head over there right now to kind of make sure I'm giving you everything that I can think of here. So when you go to it, you have a video that automatically pops up and starts playing. It's just a quick 10-minute intro to what the Human Rights Bureau is and what we do here. So it's going to be a lot of the basics of things that we've covered here today as well. But also underneath, I just finished up a video on retaliation. It's just 21 minutes long. So I think that gives a lot of good bang for your buck there, since retaliation is one of our higher filings as well. Good 20 minutes spent in your day. Like you said, there's a discrimination 101, the basics that we have there, just to kind of lay out just discrimination laws at their very most basic level. And then we switch into the topics as well. So there's a pretty lengthy reasonable accommodations video. If you kind of want to go more in depth, it'll give you some really good ideas and understandings of steps to follow, of examples of what includes a request for an accommodation, like what Marique was just going over. So it walks you through some of that, gives you examples of what cases we've had, and even some kind of things that maybe most people wouldn't even recognize. So it helps you to get a good grasp on that, and then also walks you through some suggestions of the process you can do for the interactive process as well. And there's a pregnancy discrimination video on there. I've got a harassment or hostile work environment video up there as well. And then I've also got a link. You mentioned the diversity issue. I gave a presentation on that as well for one of the Blueprint for Business Successes just in February. And so that was through the Kalispell Job Service. And I've got a link to that you can find as well if you want to learn a little bit more about that topic.
That was perfect, Andrea. Thank you for sharing all that good information. So for employers out there, I would hope they would take a look at what you have provided there, and also what is on the Human Rights Bureau's website, just as far as resources, just to be able to provide a background for employers as they're trying to figure out their policies and procedures. And then again, reaching out to the Bureau if a complaint is filed. So we're closing in on the end of an hour here. I want to thank you both, but also ask you if there were a list of things you wanted employers to walk away with today, what would that be? So Andrea, I'll start with you and then go to Marique. What is it that you want employers to remember?
I guess first and foremost that we're a resource that's here for you. Don't be afraid to reach out to our office, to reach out to me or Marique individually. On a resource slide there, you have both our contact information. We would much prefer that you reach out to us and give us an opportunity to inform you better or give you the information that you're seeking rather than try to go it alone. So don't hesitate to reach out and let us know what questions you have that maybe we haven't answered here. And like you've mentioned many times, Kathleen, and I thank you for that. Please go over and visit the YouTube channel as well and let us know, give us feedback on that. If there's anything that you have questions after watching any of those, feel free to reach out to me. Thank you.
Thanks so much, Andrea. Marique, what about you? What do you want people to walk away remembering today?
Well, one thing I'm going to pick up on is that we do want suggestions for our YouTube channel for presentations that you do want to see. So definitely let us know what topics you're interested in. But what I want folks to walk away with is that sort of annoying enthusiasm that I have for the laws and for the state's administrative process. And if anybody ever wants to simply discuss the administrative process or the laws that are enforced and get excited about it, I'm more than happy to take that call.
I appreciate that. Thanks so much, Marique. I do want to thank both of you. Again, one thing that I really enjoy about these employer town halls is that employers and citizens around the state really do get to know the people that are working behind the scenes. And we have incredible expertise here at the Department of Labor and Industry, and Marique and Andrea are just two examples of that. So thank you so much to both of you for sharing all of your information and experience with the crowd today. I would also like to thank Rebecca and Abby, who are working behind the scenes with all of our slides here, and also Eric, who's been working in the chat answering any questions. We do record these, again, just as a reminder to all of you. We will be placing these on the website, and along with that will be a copy of the slides that we've presented here today. That usually takes just a couple hours for us to get up on that website. So the link has been placed in the chat box. Our next town hall, let's see, it's going to be May 19th. Again, I'm excited for this. It'll be an economic update. Our last one was about 6 months ago. So with everything that's happening, I think there's going to be some really good information that we'll be sharing with all of you today. So with that, I would like to again thank my panelists and thank all of you that dialed in today to listen. Please feel free to again add any other additional information or requests for future employer town halls in that chat box, and reach out to any of us if you have any questions or need more information. We're certainly here to serve you. So with that, we'll end today's town hall and just thank all of you. You guys have a great day. Thanks so much. Bye-bye.
Thank you so much.